Good afternoon. Are we on? Good. Yeah. Before we begin our afternoon proceedings, I'll say that again. Before we begin our afternoon proceedings, I would like to call to your attention a distinguished guest to our university for a day. In a few moments, I will be introducing the Arthur Kania Dean and Professor of Law at Villanova in the building that houses the University of Scranton's Kania School of Management. So we are honored to have with us today Arthur Kania. Arthur is the benefactor of that deanship and our School of Management. I had the pleasure of serving on the Board of Trustees with him many years ago. So please, again, join me in welcoming him. And he's interestingly looking at ways to connect our two institutions, which is always an interesting and vital thing to do. Yeah. So, Mark Alexander is as I said, the Arthur Kania Dean and Professor of Law at the Villanova University. His expertise includes constitutional law, criminal law, the First Amendment, election law, and campaign reform. A graduate of Yale Law School, he earned a bachelor's degree in architecture from Yale University. He will focus on a topic that is all too timely, the Supreme Court at the intersection of law and politics. Please join him in welcoming.
Wow, thank you very much, Sandra, for the introduction, and it is great to be here with everybody, and particularly with Art Kania. Art and I actually were together last night on the Villanova campus, so I think he's either going to get sick of me or just we're going to take a little Martin and Lewis road show or something like that. But it really is. It is an honor to be here. I'm very excited to share with you some thoughts about my topic. Yeah, the Supreme Court at the intersection of law and politics. When I first came up with this topic and discussed it with Sandra, it was many months ago, and Justice Anthony Kennedy was on the bench. He had not announced that he was retiring. There was no vacancy. There was no nomination. Judge Brett Kavanaugh, with whom I went to school. I went to college and law school with him. We were close friends, but still I thought, I know who he is, but most people don't know who a judge is in Washington, D.C. He was fairly anonymous. But now we're enmeshed in a very significant swirl of confirmation hearings, debates, and the ultimate vote. But having said that, my speech isn't really about whether he's going to be confirmed. That's the topic of the day. We couldn't have been quite that prescient, but it is related. It's related to what he does and what the court does. In theory, we have justices of the court who are supposed to be removed from politics due to their lifetime tenure. But this protection does not mean that they don't understand politics and they don't act in ways that are political. And certainly, the Kavanaugh nomination can be seen as Exhibit A. Inevitably, the justices are involved in political matters and important cases that shape the nature of our political system. So with my time today, I want to start with a little background, and then I'm going to give 3 examples from areas of law, and then discuss the ramifications of these examples for our country. I don't assume that you are all lawyers and or law students, so I will be giving more of a lecture about these. If it was a law class, in fact, I know 2 lawyers in the front, and I might start by calling Mr. Kania and ask him to stand and recite the facts, but that last happened in the 1950s, so I won't make you do that. But instead, I will talk about these cases, and I'm happy always to take questions when this is over to if I need to clarify those explanations. But I'll try to run through them, give a little bit of explanation, but not dwell too much. So the main concern I have really is that these judges supposedly, or sort of in the theoretically apolitical judges, they have a huge impact on politics. And that may be a good thing, it may be a bad thing. But I think we don't acknowledge that it is the reality, and that's to me a concern, and that's a big problem. So who are we talking about? Well, this is the Justice of the Supreme Court here, Justice Kennedy in the front row, second from the left, of course, has stepped down, so that is a former 9. And we'll talk about the U.S. Supreme Court a bit. I'll talk about the justices themselves, but also as I talk about the court, the U.S. Supreme Court, and the justices on the court, it's in a general way also to be referring as a general matter to all courts and the judicial branch of our government. Now, of course, we have Article 3 of the U.S. Constitution, which defines the judicial branch. And Article 3 says, and I quote here, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office." So there is a Supreme Court, lower courts later established, and the judges enjoy lifetime tenure, and their pay can't be reduced while they serve as judges. This structure, these measures are designed to protect the judges so they can be neutral arbiters of the law, not pressured by popular sentiment. So that's the court. Let me mention another thing about the court. Something important to realize, of course, is they don't actually hear a lot of cases. There's a whole lot of cases going on in a whole lot of courts all over the country, but the U.S. Supreme Court doesn't hear a lot of cases. In fact, the Constitution limits how they choose cases with a clause called the Case or Controversy Clause. The vast majority of cases that are presented to them even don't get heard. They step into about more or less 100 a year, and they have a lot of reasons for staying out or for jumping into the fray. Sometimes they stay out because it's a matter that's better left for state courts. We'll talk about that later. Sometimes they don't see the cases properly belonging to their expertise. Maybe something that's better for the legislative or executive branch to resolve. Sometimes the Constitution itself doesn't authorize them to get involved. So having said that about the nature of the court, let me talk about the justices themselves. They are human beings. Let's get that straight. They're individuals who have made their way in the highest circles of law, government, and politics, with support and with intention. I would say that these aren't the best 9 legal minds in the country. Don't get me wrong, they're all very well qualified. But there are 9 individuals with the strongest credentials who had worked the system, who had backers, who played the politics, and who were at the right place at the right time. Right? This is not something that's absolute. It's very contextual, very relative. Think about Usain Bolt. He's the fastest man in the world across a 100-meter race. That's a fact. It's concrete. He runs, he gets there pretty fast. Can time it. Right? To the contrary, the selection of a justice is not absolute. It is relative. And that's okay. That's okay. But we need to start with that premise. Understand that it's a relative context. Again, all these people, I can talk about each one of them. If you want, we can go another hour after this, and I'll tell you why each one of them is impressive in what they've done. But it's a relative world in which they live. Right? It reminds me, actually, I was listening to our previous talk with Professor Campbell, talking about Rosa Parks. Right? That myth of Rosa Parks just happened to sit on a bus. One day this happened to happen to her. No, she was active in certain circles. Right? These are individuals who aren't just happening to sit there. If it was just the best 9 people in the world, I've got 9 faculty members I'd like to send to the U.S. Supreme Court. So you can look at their backgrounds, and again, look at Exhibit A. We talked about Brett Kavanaugh. Right? He worked in the Bush White House. He had prominent positions. He was part of a significant political fight, actually, before he first got on the bench. He has lots of political friends coming into this, and frankly, plenty of political enemies. And now, more than ever, he's got more of both on both sides. So this isn't pure happenstance. Right? You can look at the Supreme Court Chief Justices over time. You can go back to Chief Justice Warren, who was governor of California, famously, supposedly struck a deal with Eisenhower, deliver the state of California in exchange for that position. Right? Warren Burger was Assistant Attorney General before he went on the bench. William H. Rehnquist, he was a top advisor to President Nixon. John Roberts served both Reagan and Bush White House. Look up any justice. Again, talk about these individuals. Full of excellent work with the right people and the right connections. So it gets a little tricky. Right? The Federalist Papers, the famous collection of 85 essays expounding on the merits of the Constitution in support of ratification. In the Federalist Papers, the judicial branch was famously described as the least dangerous branch for lack of the power of the purse and the sword. So they don't have all the money. They don't have an army. But what do they have? What do these 9 individuals and what do all judges have? Well, they have the honesty, integrity of being neutral arbiters of the Constitution and the law. They can stand for equal application of the law to all. Equal application to all. Now that may be easier said than done. Again, these are human beings with lives and careers and predispositions, just like all of us. Nobody is or can be absolutely neutral. The law is not absolute and is subject to interpretation depending on scenarios, and the justices are making these decisions from their position in Washington, D.C. Now, my concern is whether they're showing their political predisposed relative side more than the objective neutral side, particularly in cases that lie at the intersection of law and politics. And if so, that may have ramifications that extend beyond the resolution of just one case. It may have ramifications to our nation's confidence in the courts and the entire system of government. So with that backdrop, I'm going to talk about 3 high-profile cases, issues, where the U.S. Supreme Court has stepped in, sometimes not so much, with different kinds of results. So, Bush v. Gore, Citizens United, and the big issue of gerrymandering. Now, there's so many more cases that are wrapped up in these. I'm not going to, again, I can go for hours on each case in great depth, but let me talk first about Bush v. Gore. Perhaps the most famous of the ones. I think pretty much everybody knows Bush v. Gore, presidential election in the year 2000. And, we had Al Gore, sitting vice president, and George W. Bush, governor of Texas. It was close, you may recall. It came down to Florida. And by the end of the night, and I don't know how late anybody stayed up to watch these results, but by the end of the night, we knew it basically was going to come down to Florida. Whoever would win Florida would become the next president of the United States. The voting in Florida itself, the results were within less than 0.5% of a margin of victory for Bush, which triggered an automatic recount. The statute in Florida said if you're going to have that small a margin, just count them again. That recount led to an even smaller margin. So Al Gore had the statutory right and in fact did ask for a second recount. Now, there's a whole lot that I'm going to move through really fast and gloss over. Because it would take, I spend 3 weeks on this in my election law class. So there are a lot of cases in state and federal court that bounced around in quite rapid fire succession. And ultimately, to oversimplify, the Florida Supreme Court was hearing this, and they were broadly permissive of allowing recounts to continue. And that they got to the point on December 8th, the Florida Supreme Court said, we're going to have a statewide recount. which was basically a ruling in favor of Al Gore. And so George W. Bush said, I'd like to appeal that, and took it to the U.S. Supreme Court. Now, I'm sure you remember, here we are at the Supreme Court, and you see there's lots of protests, lots of conversation about this, and there are a lot of intertwined legal questions. I'm going to lay out a few ideas to illustrate just some of what I'm concerned with. First, there's always a question of why we are dealing with what the Florida courts say and what the voters in Florida say. Right? We know that the election for president is not actually a national election. It is an election where we are choosing our nation's president, but the voting itself, that process is delegated to the states. Right? The states run their own elections. And they determine the electors who they ultimately want to send to the Electoral College to select the president. But the states themselves are free to decide basically how they want to run their elections, how they want to decide to send their electors. Now, we know almost every state does a winner-take-all, which was the part of the thing in Florida, too. Maine and Nebraska have different systems, but they get to choose. So that's first thing to think about. Now, another thing, some legal questions here. I want to talk about deference. And as a general rule, federal courts defer to state court interpretations of state law. Okay? Federal courts are supposed to defer to state court interpretations of state law, like how they run their elections. So it's been fairly well established that when state courts rule on a matter that's purely state law, the federal courts, like the Supreme Court, don't second guess. They defer. But the trick here is we're not just dealing with any state law. Here we have the states that are playing a particular role in the election of the nation's president. So we have a tricky mix here and questions of whether or not the court should step in or stay back. Now, a second point I want to make, a legal point, there's a statutory issue about a safe harbor provision. It's a lot to talk about. And I'm just going to point out now that the safe harbor law dealt with the timing of when the states had to submit their electors in order for them to be counted, basically. We're not going to go in deep into that, but it's a little angle just to hold on for a second. There's a federal statute, the safe harbor law, that has an impact on what the states do. Then a third legal issue that's present here is federal equal protection. And what's going to become the question is, after the voting happened, then they had to count, right? And the count was to determine who's going to be the elector in the Electoral College. And with these different counts and recounts and ordered recounts after that, there's a question of whether the change in the voting counting was a federal equal protection violation. Did the way they count votes change in Florida? And if so, that actually may be a federal issue. Now again, I'm going through a lot of stuff, which there's a lot more to explain about it. But I'm trying to make the point to you there's several interesting legal issues that were there that then came to the U.S. Supreme Court. Now, I just mentioned that on December 8th, the Florida Supreme Court said we're going to do a whole recount. Well, on December 9th, the U.S. Supreme Court stepped in and they said, stop. Stop counting now. Right? They said there's a concern about an irreparable harm. If this count goes forward without the right procedures, and we get a result that later turns out to be wrong, then that's very damaging. Imagine if the count turned out to be in favor of, say, Gore, but then it turns out that they counted using the wrong procedures and then actually properly was Bush. Imagine a final count. They said, oh my God, this guy was the president, you told us. Or vice versa, if it went for Bush, and then later on it turns out it's supposed to be for Gore. So there's a concern with the harm that would result if they kept counting in Florida, and if they had a flawed count, what would happen? So that meant that the counting stopped, and the Supreme Court tried to sort things out, and in fact, 3 days after that, they said, oh, we've got it figured out. And as we know, their answer basically was Bush wins. Now, why did they say that? Why did they rule in that way in favor of, basically in favor of George W. Bush's position? Well, now, first of all, they pointed out that this is an ordinary case in some ways. Right? Every time there's an election, there's some trouble. Machines break, the power goes out of the polling place, there's a fire or a flood, somebody doesn't get the opportunity to vote. Different things happen. But it said this is something special. The election for the President of the United States. So they have a particular concern. So it's not just, like I said before, that the states get to choose how they want to vote. But then the court says, let's think about this process involving the right to vote. And once the states have decided how they want to vote, they need to make sure that all voters are treated equally. Right? And no voter can be denied the right to vote. So it's a funny place, right? The states decide whether you get to vote. The states run the election, but the federal court says if you change that process, there may be a problem. If you are arbitrarily changing the rules, that may be a problem. So they said, well, how are we counting the votes? That's sort of the next logical question. Was the voting regular or irregular? So they said, what are we going to do with some of these ballots, like hanging chads, right? Well, the concern was, and this was perhaps, Exhibit A in that context, there's a concern for what the rules were. What are the rules? We had all these different people looking at all these different ballots in all these different ways, and there was no consistency. And so the court said this was an unequal evaluation of ballots. Right? And that's a problem with the Equal Protection Clause. Kind of like a one person, one vote. One person's vote is determined one way, another person's is determined a different way. And in the end, the court said, the Florida Supreme Court, the U.S. Supreme Court said the Florida Supreme Court said this is uneven treatment, unequal. You have varying standards in different counties. Sometimes there's an undervote, but sometimes there's an overvote. Those are treated differently. There are partial counts. The recount procedures, again, like we saw, different people doing different things. So there was no assurance of equal treatment of the ballots. Therefore, they said, stop, we're done. This isn't going to get done in time. It's already December 12th. That's my point about that statute I said earlier, that safe harbor provision. Right? That was giving some deadlines. So they said it's time to get it done. Right? It's time to get it done. And so the court ruled in favor of George W. Bush. Now, this is something where I've tried to simplify it into 5 minutes or so. So intricate. But there's a core question to start with. Why did they get involved at all? Why did the court step in at all? And what they said, what the majority said is, we deal here not with an ordinary election, but with an election for the President of the United States. This is special. We can't just let it go. We have to step in because this is so important. Again, we deal here not with an ordinary election, but with an election for the President of the United States. So, in sum, they said it's a national election. Voting is local, but it's for the national position. The state of Florida made the rules, second, the state of Florida made the rules, which they're allowed to. But third, they weren't equally applying those rules across all counties and all votes. Fourth, that is an equal protection violation, federal constitutional issue. That's what they said in Bush v. Gore. Now, there, of course, was a dissent here. There are actually several dissenters. And one of the core arguments was that the court, U.S. Supreme Court, should have paid more deference to the state court interpretation of their own election procedures. They shouldn't have taken this in the first place, they said. They could have relied on the state courts to figure this out themselves. And ultimately, they said, why stop this count? Let them go forward and let them figure it out. And if we have to do something later, we do that, but we have to defer to the states here. And the key warning for us in this context that I'm concerned with from the dissent is that they said, above all, in this highly politicized matter, the appearance of a split decision runs a risk of undermining the public's confidence in the court itself. That confidence is a public treasure. It has been built slowly over many years, some of which were marked by a civil war and the tragedy of segregation. It is a vitally necessary ingredient of any successful effort to protect the basic liberty and, indeed, the rule of law itself. We, the court, we risk a self-inflicted wound, a wound that may harm not just the court, but the nation. So what happened here? There are a lot of interpretations. There's not one clear consensus on this. Some say that the U.S. Supreme Court stepped in to act a lawless Florida Supreme Court. Some say that this is all, a proper distrust of democratic institutions. Good to step in. Some say the role shouldn't step in at all in these electoral matters. Some say the equal protection argument that I just mentioned to you, well, technically may be correct, but really not the right application of the rule. Some said, of course, just give it back to Florida, let them sort it out. Some see this as saving the nation from a crisis. Some, of course, just throw up their hands and say it's all partisan politics. So however and whatever you think, that's a big discussion, right? 3 weeks of my election law class. But my concern for today is, did the court step in and save the country, in a sense? Or did they suffer this self-inflicted wound? This is as high profile as you're going to get. It was great theater, indeed. It was great politics. But how are we after the fact? How does the court look? So let me change to another topic. Citizens United, campaign finance reform. 2010 decision. Okay, I'm going to give you 3 cases, remember? So this is about campaign finance law, Citizens United. The McCain-Feingold law, the Bipartisan Campaign Reform Act, amended the Federal Election Commission, and basically it regulated the financing of political campaigns. And there are 2 core issues that this particular law was dealing with. The law itself was going back to sort of a post-Watergate regulations, but it was being amended here to deal with 2 main issues. One is the proliferation of what were called issue advocacy ads. That limited the broadcast of what were called electioneering communications, ads that named a federal candidate but didn't directly talk about the candidate. Those ads were set up to try to they're designed to influence an election. And so the law said if those ads are run within 30 days of a campaign, of a primary election, or 60 days of a general election, then they couldn't run. It was sort of hiding the way for the political discussion. It also prohibited corporations from paying for these ads. Now there's another issue that was dealing with soft money in politics, which prohibited the national political parties from raising and spending money in certain ways. We're not going to talk about that. We're going to talk about the first part, dealing with electioneering communications. So the case itself was triggered by a group called Citizens United, an advocacy group that wanted to show a film that was critical of Hillary Clinton within 30 days of the 2008 presidential primaries. This is the first Hillary Clinton run. And Citizens United said, we can run this, and it's a movie we're going to run on cable, on demand. And so the law doesn't apply to us. We are speaking about a candidate for office, yes, but the law doesn't apply to us. Now, the Federal Election Commission said, yeah, it does apply, and you can't run this. So in the end, the U.S. Supreme Court looked at this, and they overturned significant portions of the McCain-Feingold bill. They built it on a premise, fundamental premise, that money equals speech. That's one with which I disagree. And it starts with this case in 1974 where Buckley v. Vallejo equated money and speech and laid the groundwork for the Citizens United decision. And so, this is often what people thought about Citizens United, big bag of money having a significant effect on the individual vote. What the court did in Citizens United is they held that corporations are persons, right, on an equivalent basis with individuals like you and me, and they have equivalent First Amendment rights in the context of campaign spending. And that's core political speech. Now, in doing so, the court rejected some previous case law and overturned a couple of cases which had prohibited corporations and labor unions from spending this kind of money. And the concern was whether these corporations or unions would spend so much money they could distort the political dialogue. And so they struck down previous cases, and in an almost activist ruling, they stepped in to say, we need to allow for spending by these corporations and unions. Now, the interesting thing about this is that among the justices over the decades, really, there have been many different perspectives on this issue. And for quite some time now, there's actually been a majority on the court who would overturn that Buckley precedent, but for different reasons. See, there's no agreement as to what analysis would replace it. There's a spectrum, in a sense, and there's sort of like a couple of votes every place along the spectrum, but no agreement as to what the new framework should be. So most people say Buckley v. Vallejo doesn't work, but nobody says what's better. But Buckley is controlling precedent, as we say, in the law. It's the rule, it's the principle that must be followed. And the key premise there is that money equals speech. Speech is protected by the First Amendment, and therefore money in politics is protected free speech. Now, in this context, we have to think about how campaigns are funded. And the reality is those with money and who have access to money have greater ability to influence, greater power. The interest of money can drive politics, and those who have money and access to money in politics can have greater influence. That's, I think, the point of that cartoon. And what that does is that doesn't address the constitutional guarantee of an equal voice in politics. See, the First Amendment has been famously described as guaranteeing what's called a wide-open, robust public debate on the important issues of the day. Each of us has an opportunity and an obligation to be part of that wide-open, robust public debate. But when one person, in a sense, can amass significant sums of money to buy a bigger megaphone, then that can drown out the voices of the many, and that can skew the system. I believe that the court can and should stand up for free speech and for equality in this way. But the ruling in Buckley and Citizens United, they've set it up so the interests of the few can outweigh the interests of the many in the context of campaigns. My concern, which I've made no secret about this in writing in books and articles and Supreme Court briefs, my concern is that the voices of the many people get drowned out by the vast sums of money in politics. Remember, before I was mentioning the Bipartisan Campaign Finance Reform Act, McCain-Feingold, right? I think this is something which cuts across party lines. This is not about Democrats or Republicans, it's about how process moves forward. I am a staunch proponent and defender of the First Amendment, but I think the analysis, the core analysis from Buckley through Citizens United, doesn't consider other aspects of First Amendment values and values of equality in the Constitution. And this decision itself, interestingly, has been unpopular across party lines. Again, going back to McCain and Feingold. Right? There are lots of people who see that money has a strong influence on elections, and they are concerned that there's an inequality. And that concern cuts across race region, and politics. It's one of the few cases on a hot-button issue where there's actually significant disagreement with the ruling. Cross-party lines. So that's a second area I want to mention. Third area I want to mention is gerrymandering. Redistricting, gerrymandering. So, the U.S. Constitution requires that every 10 years, each state must engage in redistricting, right? It's a somewhat complicated process of drawing legislative boundaries based on the most recent census, the decennial census. There are a lot of complicating factors, and we really want to make sure we have a legislature and a map of districts that reflects all of us in our democracy. Now, who are we? That's a good question, though. How do we represent ourselves? Is it race, region, religion, culture, industry, rural? I mean, how do we define ourselves? And there's lots of ways in which people define themselves and lots of ways in which those who draw the maps try to define us, we the people. So that's a question of what gerrymandering happens to be. So what is gerrymandering? Somebody know what that is? A couple of familiar. Oh, yeah, I've got a hand up. There you go. Redrawing district lines to get a certain result. And this particular drawing is from the state of Massachusetts 200 years ago. Who just said salamander? Looks like a salamander. So the governor of Massachusetts in 1812 was a man named Elbridge Gerry, and he drew the districts basically in a way that was trying to preserve his own power. And they said it looks like a salamander. So they said it was Gary's mander. And it became gerrymander. So if you learn nothing else today, you get a picture from me. So it is basically, as the young woman in the back said, it's a form of redistricting in which the district boundaries are modified for a particular purpose, thereby presenting some sort of a contorted, unusual shape. Now, it can be used to achieve desired results for a party, or maybe to help or to hinder individuals, political, racial, linguistic, religious, or classes, all different kinds of ways. And when it's used to allege that somebody is gaining a disproportionate amount of power, the term gerrymandering certainly has negative connotations. Sometimes we have seen that it has positive connotations in terms of trying to provide equality on racial grounds in so-called majority-minority districts. So we've seen it in different kinds of ways, have different theories about what is it good for and why is it not so good. And what you do is sometimes you do things that are called packing, sometimes you do things that are called cracking. Now, these are common methods of gerrymandering that sometimes will minimize the impact of particular voters. In packing, you concentrate members of a particular group in one district. So that district is very heavily whatever that group happens to be. So they, in a sense, get a guaranteed win, but then you might also say they don't get other districts where they're very well represented. So cracking sometimes is when you take those people and you split them up among a lot of different districts, and you dilute impact. So you sort of concentrate, or you can dilute the impact of individual voters. And those methods actually are used often in conjunction with each other. And nowadays, frankly, with apparently limitless technological abilities, you can do almost anything in drawing district boundaries. And it's been done in many states, including in Wisconsin, that I'll talk about now, with a bill they called Act 43, which was their redistricting plan from 2011. And that plan systematically diluted the voting strength of Democratic voters statewide. Now, let me make one point clear. This is a case that came to the Supreme Court where the Republicans used their power to put the Democrats out of power. This doesn't belong to the Republicans. Doesn't belong to the Democrats. This is about power, right? When Democrats have power, they do this. When Republicans have power, they do it too, right? This is a case that went to the court that we need to think about. that is illustrative of how these things go forward. So what had happened here in Wisconsin, for the first time in over 40 years, the voters had elected in Wisconsin a majority of Republicans in the Assembly, in the Senate, and in the governor's mansion. With that power, they passed Act 43. Now, the interesting thing is that the Republican Party in 2012 received 48.6% of the statewide vote. Now, under that map, they won 60 of 99 seats in the Assembly. So that's just over 60%, with 48% of the vote. In 2014, the Republican Party received 52%. So one time they're a little under, one time they're a little over. That time they won 63 seats in the Assembly. Clearly disproportionate to their overall statewide share because of the drawing of the map. See, the Republican plan had ensured that they had more seats in the legislature, more than their proportion among the voting population. And those results, importantly here, those results would stay locked in until the 2020 census. You do the census once every 10 years, you do the redistricting once every 10 years. So one political party used its advantage in the Assembly, the Senate, and the governor's mansion to keep themselves in power, disproportionate power, for a decade. The Republicans, again, in this context, the Republicans locked out the Democrats through gerrymandering. So the legal question was whether Act 43 was improperly intended to burden the representational rights of the Democrats for those 10 years by impeding their ability to translate their votes into legislative seats. So how do you answer that question? There's two main questions. First is it the role of the courts to get involved in the first place? Should the courts intervene in redistricting and gerrymandering cases? As I told you at the outset, the Supreme Court does not hear every case when they're asked. Many cases involving politically charged matters, they stay out. And instead, they defer to the political branches. Let them sort it out. If it's political, they may stay out. But if the justices see something as a matter of law, they have a reason to step in and resolve the dispute. It's called justiciability. I sort of referred to that idea earlier today. And so the Supreme Court may not find a political gerrymandering case to be justiciable, because they may say the political parties aren't the ones we're going to protect here. Right? In some contexts, political gerrymandering may be unconstitutional, but the court has not decided whether or not a suit involving political parties in this context should be heard, whether it is justiciable. Right? The Supreme Court doesn't recognize that political parties have a particular protected interest under the 14th Amendment that others do. So there's a tough question about whether or not there is a reason for the U.S. Supreme Court to get involved in this. So, should they get involved? Well, I think they should. But part of the question is why they should get involved. See, my concern is that if courts don't intervene when there's political gerrymandering, then when a majority political party can enact a plan to redraw the districts to maintain their majority over a decade, then citizens outside, whatever that minority party is, they are unable to seek any redress against the government. And in Wisconsin, again, remember, in one election it was 48% one way, and one election it was 52% one way. It's a fairly split state. But because of the gerrymander, the Republicans would maintain control over the course of 10 years, and in a significantly disproportionate way. Right? So the idea of sort of equal protection for all is challenged. Democrats, in that context, were locked out. And we are, of course, we are in a two-party system. And so you freeze people out of participation. And so the ruling party basically locked out the party in the minority, even if they didn't win the majority of votes. So there's a lock on government, even in a fairly evenly split state. And the citizens who were Democrats, in a sense, couldn't get their representation in government because the voting perpetuated a majority of power for the Republicans for a decade. And that prevents proper democratic functioning. And the process breaks down because the citizens, if the courts don't step in, there's nowhere to turn, right? The political process set this up, right? The politicians, the Senate, the Assembly, and the governor. That's two of the three branches. They created an inequality. So if the courts don't do anything, then who's going to resolve this problem? How are they going to voice their concerns against the government? How is it possible that our government will not speak to the needs of half the people over the course of a decade through pure politics? So in that context, I think it is important for the courts to step in, because otherwise this problem doesn't get fixed. Now, still, there's a question, even if the courts step in to review this, there's still a question of how you decide whether or not the district lines were drawn properly. What test should the courts use? And that's actually quite hard. So if the courts get past the first question, they still have the second question, right? The first is, do we get involved? The second is, well, if we get involved, how do we sort it out? The lower courts in the Whitford case, this Wisconsin case, had a formula. And they said, if this redistricting plan is intended to place an impediment on the effectiveness of the votes of the citizens on the basis of politics, if it has that effect, and if there are no other legitimate legislative grounds, then that's unconstitutional. So basically they're saying using pure, raw politics as your excuse for drawing district lines, if that's all you're doing, with no other reason, and you're actually achieving that effect, that's not okay. And so the lower court said that Act 43 was, in fact, unconstitutional. Now, there's a lot of legal concerns in here, technicalities of constitutional doctrine, and a little bit of gerrymandering math, and a lot of gobbledygook in all the different opinions. Trust me, don't read them all. It's just, unless you're looking to get some rest. But, you know, I don't want to lose sight of the broad principle here, which is if you set the rules, you control the outcomes. If you set the rules, you control the outcomes, and that's what's happening here. And the question then is it okay to stack the decks? To stack the decks so that for 10 years, or who knows, maybe longer, but at least for 10 years, one party, even if it gets a minority of votes, can get the majority of the seats. To me, that seems anti-democratic. To me, the problem is we risk a loss of credibility in the political process. And ultimately, if the courts don't do something, we risk a loss of credibility in the judicial branch as well. So this case came up to the U.S. Supreme Court last term. And you know what the Supreme Court did? They punted. They said, well, you figure it out. Not even that, actually. They said there's a technical legal issue as to the exact plaintiff and the harm to that exact plaintiff. Right? You have a plaintiff in any case. So there's an individual, there's actually several individuals who stepped up, and the question was that the right person to represent this problem? So they really, they avoided this question. They worked hard to avoid it, I would say. But the central issue does not go away. Or I guess the central two issues. One, is it the role of the courts to hear political gerrymandering cases? And if so, what are the standards for the legal analysis? Now, that's what happened with this Whitford case going up to the U.S. Supreme Court. We have another angle I want to discuss, which actually we happen to be discussing at lunch today as well. I should call on you, Maury, because we have a situation in Pennsylvania, right here, Pennsylvania. So fairly recently, the Pennsylvania Supreme Court ruled that our legislature violated the state constitution when the legislature drew the map back in 2011. According to the state Supreme Court, the Pennsylvania legislature's action violated the state free and equal election clause. So they said, bad line drawing. The state Supreme Court said that. In response, what the court did is they said, you got to go draw a new map. But the justices warned, if you don't come up with a new map that meets constitutional standards, then we, the court, will redraw the map. Well, the legislature and the governor failed to achieve a satisfactory solution. And the court ultimately redrew the map. All appeals have been exhausted up through the U.S. Supreme Court. They're not getting involved. Remember that thing I said before about don't second guess the state courts? That's what the U.S. Supreme Court said here. We're not going to get involved. So the Pennsylvania justices, their ruling stands. And that's the districts that we will be voting on in a couple of months, less than a couple of months, right? What's interesting, though, is that a few months ago, there was some pretty significant talk of impeaching the justices on the Pennsylvania Supreme Court who had ruled that way. Basically, allies of those who had lost sought to impeach or wanted to impeach the justices who ruled against them. So politicians on the losing end were seeking to remove justices with whom they disagreed. This is, to me, a recipe for disaster. A free nation depends on an independent judiciary and the rule of law. Threats to impeach justices based on politicians' disagreement over legal rulings are fully antithetical to the principles that make our nation great. This is a political attack on the rule of law. And I tell you, we are nothing without the rule of law. Now, I know it's fun sometimes to make fun of lawyers. It's a little sport sometimes. But truly, I believe that the reality is if we want to ensure a strong society, we need to protect lawyers in the context of how lawyers protect the rule of law. Markets, free markets, depend on the rule of law. Our sense of right and wrong depends on criminal justice and the rule of law. Government itself is the rule of law. And our court lives at this strange intersection of law and politics as we protect the rule of law, and in these cases needs to be very careful. In my election law class at Villanova Law, we talk about hot topics like these: campaign reform, voting rights, etc. Week after week, we see cases from all over the country. By the way, there's cases from all over the country on all these topics. But with all these cases, from Bush v. Gore to Citizens United, we see that ultimately the winners celebrate and the losers vow to challenge. But ultimately, we all move on and we move forward. When the Supreme Court generally rules on controversial topics, like the death penalty, free speech, abortion rights, we move on and we move forward. We don't impeach judges that way. The U.S. Supreme Court 200 years ago, Marbury v. Madison, declared, "It is emphatically the province and the duty of the judicial branch to say what the law is." Emphatically, the province and the duty of the judicial branch to say what the law is. In that case, Marbury, the court established the power of the courts and the key principle that when courts speak, we must follow the rule of law, as the courts have declared. In order for our system to function, our courts and judges must work independently, as we talked about in the very beginning. They need to act independently without fear of reprisals. That's why we don't let them lose compensation, right? The courts are not perfect, but they are essential to who we are. And in Pennsylvania, in our particular context I'm talking about here, the Chief Justice, Tom Saylor, he dissented in the redistricting case. He was in the minority who disagreed with the ruling. Yet he spoke clearly in defense of his colleagues on the other side of this case. And he spoke clearly in defense of our system. Quote, "Threats of impeachment directed at justices because of their decision in a particular case are an attack upon an independent judiciary, which is an essential component of our constitutional plan of government." So those who seek to impeach Pennsylvania's Supreme Court justices, well, they're not likely to succeed. But their actions reflect a fundamental misunderstanding of the greatness of our nation. The point is not that you can always win in court, but you can always have an independent court where you can be heard, no matter how rich or poor, famous or anonymous, well-connected or not. We must respect the rule of law. The rule of law, as declared by the courts, is what makes us great. No other nations have lived for so long with such great strength as ours with these safeguards. It is uniquely American and deserving of protection. So those are three areas. Three broad areas of some cases and some issues, which I think the courts, sometimes they get it right, sometimes they get it wrong, but I think there are always ways they can rise above. But my main concern here really is equal justice under law. You know, that's the promise on the front of the Supreme Court building. Equal justice under law. Now, we can look back infamously in our court's history. Plessy v. Ferguson, the Supreme Court embraced the principle of separate but equal. But nearly 6 decades later, in Brown v. Board of Education, they overturned that original mistaken decision. I think we are in no less momentous times now on the issue of rule of law in our political system. See, the courts themselves are in a unique position. But remember, courts are conservative. Not in the sense of conservative versus liberal, Republican, Democrat conservative, not at all. But in the sense that they wait. They hear cases that are brought to them. They rely on precedent. They are slow to change. So judges act infrequently, and they have to act with great care due to the limited role they have. They need to be careful when they step in to political cases. Step in when there are issues of law, but stay out when they face issues of politics. My concern is that today, the political branches of government are seen with very low esteem. Right? The president's approval rating is very low. Congress, forget that. Their approval has been in the teens for quite a while. But it's not always been that way. You only go back 10 years and you start to see different numbers for approval ratings. For Congress. For Congress, you know, about 10 years ago they were in the 20s and 30s, and about 5 years before that they were in the 30s and 40s, and before that they were even higher. Right? Dramatic differences. We are in some sort of a slide. I'm not here to blame anyone. But I do think, and this is perhaps my perspective as a lawyer, with Congress and the president, those two branches in such a place, the courts and the U.S. Supreme Court, can rise to give people greater confidence in where we are going. I believe our system of checks and balances demands nothing less of the least dangerous branch. You know, if we look back to Brown v. Board of Education in 1954, the court declared principles of equality found in the Constitution. The political system had not gotten there, right? We are still a decade away from the major Civil Rights Act. But as one of the co-equal branches, the court stood up for the people. And I think the court needs to think about that going forward. The people believe that the court is supposed to stand up for us, whatever the popularity of the position. No matter what, we have equal justice under law. But when the people see powerful interests getting the upper hand in political cases, we can lose faith in the entire system. When judges appear to be taking political stands, then the fact that they have political backgrounds, like we talked about in the beginning, the fact that they have political backgrounds and political instincts, that gets a little more noticed. When they seem to be acting more in the interests of the many, rather than when they seem to be acting in the interest of the few, then the people see something different. When they act in the interest of the many, they fulfill the promise of being neutral arbiters in defense of the Constitution and the laws. See, politicians have to be elected and reelected. They often stand up for what's popular, and they often get buffeted by the winds of temporary popular opinion. But the courts are supposed to stand up to and against the winds of change and the swirl of the day. But when that doesn't happen, the people can lose faith in the government overall. So with the President and the Congress already at low points, the last thing we can afford is a Supreme Court without high esteem. To me, this is a threat to the pillars of our democracy. Politicians can weigh popular sentiment, but the court should not. When the court looks like it's doing the bidding of someone other than the people and the Constitution, that undermines our entire American democracy. And I believe it's time for all of us to stand up and recognize the threat to the system we face. So what about us, you and me? We the people have an obligation to get up, stand up, speak your mind. The First Amendment permits it, protects it, and I think even demands it. So work for a candidate if you want. Vote. Go debate somebody. Have a good conversation. Sit at a coffee shop with a friend with whom you disagree. Talk about it. Engage. Get involved somehow. See, my favorite part of the Constitution, I'm a con law professor. Like, I'm dean, but I'm a con law professor, so I actually have a favorite part of the Constitution. I'm allowed to do that. You're allowed to if you want to, but I have to. My favorite part, actually, is found in the preamble. And it actually reminds me of what Professor Campbell was saying earlier. My favorite part is in the preamble, where we declare this Constitution is established in order to form a more perfect union. God, I just love that. Right? It's in order to form a more perfect union. Not perfect, right? Not perfect. And by the way, that Constitution wasn't too friendly to me, right? So, like, I'm not saying that was a great Constitution, but it's more perfect union. We are trying to form a more perfect union. It is aspirational, our Constitution. So today, with all of you here at the Schemmel Forum, I just hope you take my comments as my attempt, through my words, to contribute to our nation and to our all getting better all the time as we try to form a more perfect union. Thank you. Please.
I want to follow up on the last points that you were talking
Sure.
about. The concern of mine, when you look at the broad history of the Supreme Court and what's made up of. We know for the first 180, 190 years, it was all white men, mostly Protestant, a handful of Catholics, a handful of Jews. But they did have some diversity in background, political diversity. We have a former president of the United States, William Howard Taft, who sat on the court, Senator Hugo Black, Governor Warwick, as you indicated. And we had practitioners. We had Abe Fortas, Goldberg, etc. And then, of course, we finally got a woman on the court. And we did have some diversity of background. She came from Arizona, was on the court there. She went to Stanford. Justice Souter came from New Hampshire, was on the state court. But over the last 20 years, we seem to have seen an orthodoxy appearing in the court. Everybody that was in that picture that you showed at the beginning and Judge Kavanaugh have a background in either Harvard or Yale. I hate to say it, but none of the students that you taught or are teaching now have a chance in heck of making the Supreme Court. And most of these people now are centered in Washington.
Sure.
They come from the D.C. Circuit. They come from Judge Silberman. They practice government law. They don't practice with the people. And I think they've lost touch with the people or common problems. And so I'd like to kind of comment about this kind of orthodoxy that we're in.
I think it's a great point. Sure, I think that's a great point. So I would take that another step. So I'll make it personal for a second, right? I went to Yale College, I went to Yale Law School, and I am Catholic. That means I have a 99% chance of being in the pool of people who might be considered. If I had gone to the same schools and was Jewish, I would have a 99%, because that's the only people who are on the court. We have at the moment, and assuming that Brett Kavanaugh is confirmed, right? And so first thing I'd like to change is, we'll get some Villanova grads, right, Art? So I take that as a challenge to make sure we have the first Villanova Law grad. But I think that the challenge is this, I am very proud of where I went to law school. I received an excellent legal training, but I think it is narrowing. I think that we are in a position where we see that there's a narrowing group of people who are on the courts, and that can be detrimental. And I think we have been in different places, and I think right now we are in a narrow place, and that is, I think, also I think that could have detrimental effects ultimately on the court. I think you're right to raise that, and I think that's something where I don't know what's going to change it besides people demanding something different. But the reality is, with 9 picks, 9 seats, it has to be something that happens as you sort of bubble up. We have some wonderful judges from Villanova Law who are on the federal district courts, but it takes a long time for someone to get from that position all the way to the top. So I think that is a big challenge. I can't say I have an answer to it, but I think you're correct to identify that we have a skew in the population set who are put on the court.
Maybe writing some articles in legal journals and start a discussion a little bit more.
Okay. Are you a lawyer, by the way?
Guilty as charged.
Question.
Yes, ma'am.
Justices are supposed to be apolitical. Should that disqualify anybody who was involved in a political position, such as in the White House?
No, I don't think that. I don't think that one's political engagement should disqualify them from serving on the bench. I am concerned, though, that that politics can weigh more heavily than what might be considered a more apolitical application. I think that we don't want to set it up so that we eliminate vast swaths of people, because ultimately, remember, people in politics, elected officials, for example, they're public servants. I think there are people who serve their state and their country or their city very ably through the political system. So I wouldn't want to rule out people, but I do think we have to understand that these are people with political biases. And I think we also have to understand that as we look at how our system functions, we need to maintain faith in the system. And sometimes if we have lots of people who are involved in politics, lots of people from particular Ivy League schools, then that does make a narrower band of people. And that's something which I think illuminating it, and that may be also to the gentleman's point, we need just to illuminate the reality here.
Two things. I have a feeling that gerrymandering shouldn't be there at all. Yeah, because it's so politicized.
Mm-hmm.
But the question I wanted to ask is how the impact of monetization of politics,
right,
and how that may be the reason that it's so lowly admired,
mm-hmm,
and people feel pretty discouraged by
right,
our politics.
So the first point just about gerrymandering, there's no doubt that what people see is an opportunity to entrench certain power with this line drawing. And I would love for us in our legislative bodies, I would love for legislators to start thinking about representational rights more than anything else. And that's something which I think is a lot of people I think are dissatisfied, so hopefully we can make some progress on that. But as long as we have sort of a winner-take-all system, that's going to be about power. And it's hard to get people to step away from their power. In terms of money, the concern is that money does skew, right? If you ask any, call any congressman or senator and ask them how they spend their time, and this has actually been, was even documented in the U.S. Supreme Court, and by the way, across all different perspectives on this issue, everyone recognizes that elected officials spend an extraordinary amount of time on fundraising. So that skews, right? If I represent you, you're my state I represent, and this group makes a lot of money that I need for re-elections, I might like all of you a whole lot, but I need to get the money, so I'm going to talk to them. Nice people over here, right? But just by talking to them so much, I hear different things than if I talk to you. If this is the east part of the state and this is the west part of the state, I don't know what you care about in the west. I like you lots, but I'm spending time over here. Again, this is something which to me transcends politics. Democrats, Republicans, right? So there's ways in which that's a little metaphor using this room. But that does skew politics, right? And what I'm concerned with in this situation is that this group, 20% of the room, have more say than the rest of you who are the 80% or 30, maybe a third, whatever you happen to be, right? But this is the majority of the room, but this is who I'm listening to. And the reality is it's not that it's an 80-20 split. Right? It's a 90, 95, 99% split. Right? I find it so interesting our nation where we are so driven by powers of democracy and capitalism. Both are essential to each other and for each other. So it makes perfect sense for us to understand that the forces of capitalism must propel us forward. But when the two get together, that's the interesting challenge. Right? What do we do in that context? If we have a promise of equal justice under law, and if we have what we consider to be a representative democracy, but some small number of people are being heard more than others in the political process. And again, this is not Democrats or Republicans or libertarians or anybody. Then that can have a skew on the system. And so that point of equality, and when we were talking about the Equal Protection Clause back in Bush v. Gore, equal protection, equal justice, I think that's what we need to make sure we focus on, equality in our political process. Yes, we've got...
Just two quick questions.
Yep.
I carry the Constitution around with me, but I don't read it a lot. Was there something in that article that guarantees lifetime for the Supreme Court?
Yes.
Okay.
They can be impeached.
Okay.
Right, but
the Constitution says it's for life.
It's a lifetime appointment. There's ways in which you can be removed from the court, but fundamentally.
Yeah, I mean, if you don't screw up, you're there for life. Or you become mentally, obviously, incompetent. You could be removed.
You can be removed, but it's just not easy.
Okay. And then, when would the Constitution preclude the Supreme Court from taking a case? You said that.
I'm sorry, can you just say that again?
You mentioned that this Constitution
right.
could preclude.
So, yeah. So, the Constitution speaks in terms of cases and controversies. So that's just, getting into our now I guess I know at least 3 lawyers in the room. I don't know if there are more. They're starting to sweat and think of like their first year con law cases. The Constitution says that the court can hear cases or controversies. So that has been interpreted as being a limit. So that, for example, they don't give advisory opinions. So there's an actual dispute, courts step in, but they don't give advisory opinions because that's not seen as a live case or controversy, right? That's the sort of one easy shorthand example. Yeah. There are other ways in which, in sort of the state law context, where the court stays out, because the Constitution basically says states do their thing, federal courts do their thing. As long as they're in the state territory, and what the court has said to interpret that, it says if there's adequate and independent state law grounds for a matter over here, federal courts don't touch it. So that's say there's certain ways in which the Constitution limits what the courts do and what they hear, which is why, again, I say they're conservative, and why I also think it's so important when they do act, they have to be very careful because they're not standing up so much, right? Which is fine, but it's a tricky role. I think there's a hand back there.
Do you think that the change in the Senate filibuster rules immediately preceding Justice Gorsuch's confirmation to the court are going to have a significant impact on nominations going forward? And do you think a change in the political majority might bring about a change back to that rule? And if not, why not?
So I can't just say yes or no. So I think I'll answer the question by just talking for a minute, and I'm not sure how this ultimately answers. I'll see about that. So I just think back to a time and sort of, not quite at the risk of Professor Campbell correcting me, because I don't want to over-romanticize, but I think this actually, he may agree. We're in a very different time, and there was a different time of operation in the U.S. Senate. I will say from personal experience, I worked in the Senate in college, and then after college I worked before I went to law school, and it was a different time. It was a time in which on Monday morning the majority leader would get onto the floor and he would announce what was happening for the week. Monday we're doing this, Tuesday we're doing that, Wednesday we're doing that, last vote will be Thursday at 4 o'clock. Whatever. And by the way, if he said the last vote was Thursday at 4, you could plan the last vote would be Thursday at 4. You also could plan pretty darn sure that Wednesday night was going to be really difficult for you because you had to get things done. And Tuesday was going to be pretty challenging. But you knew this is what you had to get done for the week. And you knew that if it was going to be, we're going to work on the EPA. If you worked on environmental issues, you knew that you were going to be there all night long for 2 or 3 nights. But you knew if you were working on defense spending, that quieter week, but the next week would probably be hard. But it was a time in which they would debate, they would go forward, and at a certain point they'd say, we're going to put it to a vote. And thumbs up, thumbs down. So there was, I believe, a different time in which there was much more comity, much more agreement, and much more of a reason to agree, to disagree sometimes. I grew up in a household in Washington, D.C., where my family were involved in politics, and we would have Democrats and Republicans at our dinner table every night. And we would always, it's always hugs and kisses for Uncle so-and-so or Aunt so-and-so when they were coming in and leaving. And, I'd hear my parents having little fights over the policies of the day, and always hugs and kisses at the end, because those were my aunts and my uncles growing up. My parents' brothers and sisters, not related to us. But that's how we treated each other. So again, maybe I'm over-romanticizing a bit, but I do know that there was a better time. And I'm shamelessly optimistic. I think there is a better time ahead. I don't know, to answer the specific question, how soon that's going to come about. I don't think it's going to happen the next several years. I think we're in a very low point, and it's going to take years to cycle back out of it. 5, 10 more years, and I'm not sure what's going to break us out of there, but something can. Because, in fact, we are trying to form a more perfect union. Thank you.
I think this has been a wonderful opportunity to actually celebrate Constitution Day, which is coming up in 2
Monday.
days. Yeah, so I consider this part of the celebration, and I couldn't think of a better way to do it. So we're going to give you a 10-minute break. Okay, and we'll be back for the art part of the day. Really. I always say